Hey. Hello and a very good evening to everyone present today at FDPPI's Janavardhani webinar series. Today, the topic for discussion is a conversation on proposed arbitration and mediation rules of FDPPI. For the conversation with us, we have our Navi, very own Navi, and Mr. Dr. Amit Khatu. We welcome you today, Mr. Amit, for the session. Uh, Thank you for joining us. Would like to give a brief introduction of Mr. Amit Kumar. Dr. Amit has obtained his LLB degree in the year 1999 from ILS Law College, Pune, one of the oldest and the premier law institute of the country. He completed his master's degree in law from Department of Law, Pune University. He was awarded PhD by Pune University for his thesis titled Legal Aspects of Cybersecurity in India with special reference to data protection. A critical study from ILS Law College, Doctoral Research Institute, Pune. Dr. Amit is based at Pune and has been legal advisor to many multinational corporates in the field of renewable energy infrastructure and aviation, logistics, information technology, to name a few. He has over 21 plus years of experience in drafting and negotiating commercial contracts, technology transfers, and risk mitigation aspects of business ventures. He has over he has a vast experience in civil and criminal litigation as well as arbitration, and has handled hundreds of disputes in various levels of courts as well as alternative dispute resolution through arbitration and mediation. He has been law officer to Maharashtra Police as well as advocate to several nationalized banks and for National Highways Authority of India. Currently, he is legal counsel to Secrion, Secrion Group of Companies and has his own law office in Pune. We welcome you, Amit, to FTPPI and today's Janavardhani webinar series. Over to Navi sir and Amit for the discussion and the conversation going ahead. Thank you.
Thank you, Samita.
Okay.
So this particular Janavardhani program has been structured as a conversation with Dr. Amit because we have been taking certain initiatives for implementing the arbitration and mediation to be undertaken by FDPPI, specializing in the data protection related issues. So Dr. Amit Kumar and Dr. Limye have worked on certain draft rules. Of course, we will talk of draft rules a little later because presently we need to actually look at the draft rules after we finalize our other activity. So probably we'll go into the details of the rules later on, but today we would like to have some discussion of how we have approached the particular requirement of what we have called as the Data Disputes Mediation and Arbitration Center. There are many issues which we need to be clarified with as far as what kind of mediation, what kind of arbitration we can undertake, and what is that our members need to do to ensure that we adopt this particular process as early as possible. Okay, I don't know, when we say as early, it may take in January or something like that, but still we need to start moving towards that. So Amit being a legal professional, many of the doubts which people may have, we can get it clarified from him. Of course, as many of you know, I have been working on this online arbitration actually from the year 2005 without much of a success of getting it through to the practice kind of a thing. But anyway, after the last amendment to Arbitration Act, the Arbitration Act actually recognized certain things like electronic mail as a means of communication, giving notice, digital signature kind of a thing. Subsequently, the United Nations was also working on the ODR module. Now they have also come up with some kind of a technology note. Additionally, because of the COVID, now this video conferencing has become acceptable even for e-courts. We may still debate on whether we should go on Zoom or whether we should go on something else, but the fact that this kind of virtual conferencing is acceptable in quasi-judicial and even the judicial process is also a very big, you can say, step which has enabled the use of ODR. In fact, ODR itself has become more acceptable today compared to a few years back when I started talking about this virtual arbitration room concept. You know that in domain name disputes, we have this so-called virtual ODR process, but this WIPO process of domain name dispute resolution only meant that you send an email, the email will be forwarded, and that was what was called as ODR, that is to replace the physical meeting. But real video conference based process where we have an e-court kind of a setup, there is the judicial person whom we call as neutral in this kind of a thing, sitting on a chair, and there are two counsels, two litigants arguing simultaneously, each hearing the other. That kind of virtual arbitration room was not there a couple of years back, but now when I am looking around others, now people are coming into it, and people have been talking of using WebEx kind of a thing. When I started this ODR Global, I also started with WebEx because that was the company which had a little more of respect. Then I went to GoToMeeting. So I have tried a couple of these video conferencing solutions. And now, of course, we are on Zoom for its convenience. Probably this will stay for us for some more time. But these are all the developments which have happened. But when we proposed that FDPPI should get into this kind of dispute resolution, one reason I wanted this to be there was that FDPPI as an organization is trying to empower others as experts in data protection laws. Obviously, that expertise gets aggregated amongst our members. So we will have amongst our fold experts of not only the Indian PDPA, but also perhaps GDPR and some other countries, to the extent that nobody else, no other organization in India will easily have this multiple data protection law expertise at one place. In fact, our the Module G program today discusses about GDPR, Singapore law, CCPA, Dubai law, Brazil law, and HIPAA. So 6 different laws we discuss in our Module G program. Though everybody doesn't become an expert just because they have gone through a few days of training, at least we have to some extent made these people aware of these multiple sets of laws and how they either are similar to each other or different from each other. So gradually we are building up a global law specialization amongst the members of FDPPI, particularly those who have gone in for certification of Module G and Module I together. They will have the expertise of Indian law as well as these global laws. Now, having such people within our fold, I thought it is we need to actually contribute to the community so that these experts will perhaps be able to help the community in some way. And at the same time, it is also an expression of their expertise in terms of professional terms. It may be an opportunity for them. Secondly, we have a few legal brains also with us. And they are the persons who have now not only a knowledge of law, but also they are being exposed to this data protection, technology, etc. They have become techno-legal experts, or in future, they will become more and more of techno-legal experts. So we have to give some kind of an opportunity for them to use their talents and skills also. Just as our technology people will go into audits of data protection, etc., these legal professionals can go into this arbitration related services. So I felt that we will not only be helping the community, we will also be helping the data protection professionals who are members of FDPPI to actually be part of this process and contribute to the development of this arbitration or mediation center. Now, we have certification to create these skills. We have PDPSI, which is the implementation framework for the corporates to implement. It is logical that we also have this dispute resolution so that we have an end-to-end service to the data protection community. So this is the objective of this Data Disputes Mediation and Arbitration Center. With that as background, now I would like to invite Amit to just first of all, to set the ball rolling, explain in a few words the ADR system. The ADR is the alternate dispute resolution system, which includes this mediation and arbitration. So I request Mr. Amit to just give an overview of this ADR and its importance today as a dispute resolution mechanism.
Yeah, of course. Thank you, Navi, sir. When two contesting parties submit themselves to a superior authority to have a resolution or decision on their dispute, then the decision becomes binding. Normally, what happens that the superior authority flows from law. So the sanctity which the decision of a superior authority has, it comes from a legislation which is enacted by Parliament, and that legislation confers the sanctity on the authority. Now, this sanctity is naturally based with the courts of law, which are obviously incorporated under the statutes, like civil courts function under the Civil Procedure Code and various other substantive laws. Criminal courts functions under the Criminal Procedure Code and other substantive criminal laws. And the parties submit themselves to the superiority of the court. Now, when the question of sanctity of a decision comes, can there be something which is an alternative to this setup of judiciary, to which the parties can submit themselves and then they can bind themselves to the decision of that authority? Now, this is called something as alternative dispute resolution, which is an alternative to the judicial hierarchy, which is set up under the various laws. So this alternative, how can it be created? So the parties by themselves determine that we will submit ourselves to a certain institution or to a certain person or to a certain panel of persons who will then determine the disputes between us, which is a broad overview of the alternative disputes resolution system. Now, under this alternative disputes resolution system, what is of paramount importance is there has to be something between the parties which is recognized under the law as the arbitration agreement or the mediation agreement, whereby the parties decide that in case of a dispute, we will submit ourselves to this kind of institution or this kind of person who will determine and decide upon our disputes. So this is broadly speaking in a simple language that it is an alternative to the judiciary, and this alternative dispute resolution has a binding effect. So that is what is alternative dispute resolution system. Yeah.
Okay. So Amit, we talked about mediation and arbitration as two elements of this alternative dispute resolution, alternative to the courts. Today, we are having more than 3 crores pending cases in India. And that is one of the reasons why even the courts under the Civil Procedure Code suggest mediation as a first step of resolution. And whenever a person files a civil suit, the court will first ask, can you not have a mediation and come back after 15 days, after 1 month or something like that. So there is a recognition that the current judicial system is overloaded with pending litigation, and alternative dispute resolution has to come to help this particular ease this situation. So when we come to the data protection laws, apart from the avoidance of pendency of these cases, there is also a need to have technical expertise amongst the people who act as judges in a civil procedure, which of course is not easy because these data protection laws are so dynamic. We have 100 plus countries having these laws, each having their own way of thinking, and interpretation or jurisprudence of these data related issues is developing so fast that if we take this to the courts will have to take a long time to hear both the counsels and then come up with their solutions. Because there is no body of knowledge with the judiciary like precedences which will work or something like that. Therefore, there is an advantage in this alternate dispute resolution mechanism, because here you don't have to be an appointed judge to be participating in the adjudication or mediation process. Mediation actually is something which is facilitating two people to see things in an amicable manner. So there is less of legal force as far as mediation is concerned. Two people agree, then finally after discussion they will agree that okay, our dispute is resolved, and they sign an agreement, fine. It's in the arbitration that law plays a part, and the parties to the arbitration need to have, as Amit said, a sort of a contract. Now, normally this contract is the business contract or the commercial contract, which will have a dispute resolution clause. So normally we say that disputes related to this contract is subject to the jurisdiction of courts in Bangalore, Bombay, or whatever is the place. We not only talk about a country, but within the country we specify a particular city. And when that happens, if the dispute comes, one person is always at a disadvantage. If the persons are from different cities, the person from an outstation will always be at a disadvantage. If I am in Bangalore and if I have to file a case in Bombay, that is definitely not convenient for me. So the businessman is forced to take this jurisdiction to multiple places and have a problem. Suppose I have got contracts with people in 10 different countries, and each of those countries have the jurisdiction. Then if disputes come, I will have to be traveling from one country to another country, appoint lawyers in each of those countries, spend money. So it becomes impossible to actually resolve a dispute in a manner in which I would be comfortable with. Whereas an arbitration can specify one, it can be done on online, because we are trying to force the concept of online dispute resolution, so that we can sit in one place and simultaneously try to attend to different kinds of dispute resolutions. So that is an advantage, and expertise can be imported to the arbitration team, whether you call it as an arbitral tribunal or something like that, so that technically complicated issues can be resolved with the satisfaction that the judge has understood what is my problem and given a kind of a solution. So that is why arbitration becomes useful. Now, one question which I would like to ask Mr. Amit Kumar is that we talk of an institution called arbitral institution and another called arbitral tribunal. Now, what is the difference between this institution and the tribunal?
Yes. So the arbitration institution is a body which has a set of rules to administer the arbitration, which is a kind of supervisory body who who oversees the functioning of the arbitration tribunal. So the arbitration institution has their own rules drafted, like we have Singapore International Arbitration Center, we have International Commercial Court, then we have Indian Arbitration Council. There are several other international bodies also who have their own set of rules, and under those set of rules they have prescribed how the parties can approach them, how they can choose the arbitrators from their panel of arbitrators or otherwise, and how the arbitration proceedings will be conducted, what will be the prescribed fees, what will be the procedure, what sort of timelines will be there to file the claim, to file a response, to file a rejoinder, then again to file a counterclaim, and what would be the timelines to resolve these disputes, then how the parties can tender evidence, how they can file documentary evidence, how they can give oral evidence, all those procedures in case of the resignation of one of the members of the arbitral tribunals, how the procedure will be adopted, how the parties can agree to remove an arbitrator. So this is called the arbitration institution, which necessarily FDPPI is looking at, that we are trying to be an arbitration institution, and we are trying to incorporate a data dispute resolution and arbitration center, to be precise DDMAC, as Navi sir said, that this will be an arbitration institution. Under the arbitration institution, there will be a panel of arbitrators who will be experts from various facets and fields of information technology, like data, like security, like compliance, like audit, and several other fields of information technology. And there also will be lawyers who can also be the member of the arbitration panel. There can also be judges who have expertise into this. So there also can be other professionals who have an expertise into this sort of knowledge of technology. And then there can be also combination of legal expertise as well as technical expertise who can be listed on the panel, and any one of us can be listed on the panel provided he undergoes a certain set of training to how to conduct an arbitral proceeding. So out of that panel, parties can choose the arbitrators, so that arbitrators will be designated as the arbitration tribunal. So tribunal necessarily should not be more than one person's. One person can also be called as arbitration tribunal, arbitral tribunal to be very correct. So arbitral tribunal is the body who actually conducts the arbitration, who actually conducts the arbitration proceedings. And arbitration institution is the institution who supervises, overlooks, and lays down rules for conduct of that arbitration proceedings, and ensures that the proceedings are conducted as per the rules laid down by the institution. Okay. So parties have to have an arbitration clause in their contract, saying that any dispute arising between the parties shall be subject to the rules laid down by DDMAC. Like currently parties have arbitration clause saying that any dispute arising out of this shall be subject to the rules of the Singapore International Arbitration Center. So likewise, DDMAC will be an arbitration institute. And then there will be, the jurisdiction of that particular contract may be subject to the Indian Arbitration Act and the laws of India. So there is something called the place of arbitration. So place of arbitration, which is the place where the arbitration takes place. And the seat of arbitration, that is another concept. Seat of arbitration is the seat where the dispute, if it doesn't get settled in that arbitration tribunal, and if it goes into higher forum like application to the courts, then which courts will govern that dispute? So that is the seat. The seat determines where the parties will be subject to, whether they will be subject to the Indian laws or they will be subject to another laws or what. So that is the seat of arbitration. Then they should also have a clause as to language of arbitration, which should be the language of arbitration. So what initially we are looking at under the umbrella of FDPPI, that the arbitration under DDMAC will be subject to the Indian Arbitration and Conciliation Act 1996. So certainly the seat will be, we have proposed that it will be Bangalore. So if any dispute arises, because we are looking at the online arbitration. So in case of online arbitration, one party may be sitting at, say, Mumbai, one party may be sitting at Delhi, one party may be sitting at out of India, and they have to submit themselves to the jurisdiction of a certain territorial jurisdiction of a certain court. So that seat of arbitration we are contemplating as Bangalore, and then the governing law we are contemplating as the Indian Arbitration Act. So to answer the question precisely, this is how the institution is different from the arbitral tribunal.
Okay, now say, of course, because we are choosing the Indian Arbitration Act as the basis for our activities. Say, Indian Arbitration Act 1996 underwent a major amendment in 2015, which brought in the acceptance of electronic way of doing things. Now, in 2019, a major one more important amendment was made, which actually brought now a legal distinction between the words arbitral institution and arbitral tribunal. Now, as a person who is looking at this FDPPI arbitration system, I would like to look at the FDPPI DDMAC as a platform in which the arbitral tribunals will function. Why I'm saying this is, the arbitral institution, as per the definition of section 1 subsection CA, which is the new section which was added in 2019, uses the term arbitral institution to arbitral institutions designated by the Supreme Court or High Court. All the rest of the arbitral tribunals today will have to be called arbitral tribunals. So now FDPPI, if it wants to be an arbitral institution, we may have to be in a way accepted by the court, whether it is Karnataka High Court or whatever is that. But today Karnataka High Court has got its own arbitral institution. Most of the high courts have got their own arbitral institutions. So it will be difficult for a private agency to get we may get acceptance, but we may not get accreditation. Okay, so if people, litigants choose to use FDPPI, court may say, okay, you do it and come back if necessary. I will take a view on that. But they may not directly accredit a private sector agency. So I am trying to structure our system as a platform in which, for example, if three of the lawyers want to create an arbitral tribunal, they have to set up an office, they have to set up a back-end system of secretarial services. So instead of having an office where they will have a meeting room in which people will come and have the hearings, I am suggesting that please use our, you can say, platform. So that way, we will be steering clear of this definition of arbitral institution as a court-appointed thing. In fact, Kamal also has raised one question in the chat box, which I feel has got a similar, you can say, a thought process, that he is looking at FDPPI arbitration, whether it will be a part of an approved government scheme. I don't know. Today, we are not a government organization. Unless the Data Protection Authority recognizes us for something, we will not have an association with the government. So we will have to carry on as a private sector agency, but try to use our brand name as specialists in data protection to attract attention of disputants, so that if the disputants who are today contract people. Okay, when they write the contract, dispute is not there, but they have to have a dispute clause. And at that time, if the advocates who draft the contracts tell them that there is one way by which you can either avoid or postpone the when going to the court by having an intermediary process at the contract level, we have to be shown there as if the dispute arises, then we will resort to the mediation or arbitration from the FDPPI platform. Now, FDPPI platform will have a draft set of rules, which is more like a suggested rules which the arbitral tribunal can adopt. So, if say ABC form an arbitral tribunal and they want to do business under the FDPPI banner, they will adopt our rules and make it as rules of this ABC company or ABC team of arbitrators. Now, if another EFG wants to have another this thing, they can have their own arbitral tribunal. And if they feel one or two clauses which we have included, whether it's a language clause or some other clause they want to modify, they want to do only in English, let us say. One advantage of this virtual arbitration is that it can go beyond the language barrier. And if we see that in future, the data protection related disputes will arise because of the consent permissions in which language becomes an issue. So when you are talking of permissions granted by a villager to a app owner is a matter of dispute, then if you want to accommodate the common man, you may have to go into the different languages also. So one arbitration panel where the arbitrators are conversant with the language. For example, if I am there, I will say, you talk in Kannada, I don't mind. Another person will say Marathi, kind of a thing. So there may be different arbitral tribunals working on the FDPPI platform, some of which may take, say, we will have only English, or somebody may say we are prepared to go for Hindi or some other language. So I anticipate that there could be multiple teams, which may be single person or three persons. Normally, arbitral tribunals will be having odd number of people, and where there are, this has to be again provided in the arbitration clause, whether they will go for a one arbitrator kind of a thing or multiple arbitrator, because that may have some costs involved, because the arbitrators have to be paid some fees. So at that time, they will decide on where, first of all, they will have to say that we will use FDPPA platform. Second, they will say applicable law. If they are Indian, the applicable law will be Indian. So, and whether it is one arbitrator or three arbitrators. Normally, when three arbitrators are there, the process which is suggested from our Arbitration Act is each of the two disputing parties, assuming that there are two disputing parties, they will suggest an arbitrator. Now, those two people will select the third arbitrator. Now, this from which subset these three people emerge, that is what FDPPI will try to help. We will be having a list of, I don't want to say accredited arbitrators, because we are not big people to accredit somebody. For example, if somebody has got 15 years of arbitration experience in general, ADR, though he may be new to data protection, I don't want to say FDPPI will accredit you. Rather than that, we will say we will have registered list of arbitrators. That is those people who are willing to work on this platform on data protection law. So there will be a registered list of arbitrators, and with some brief description of their background and other things, what is their specialization, etc. And the disputing parties will go through those pages and then decide, okay, I will suggest this person, I will suggest that person. And sometimes in many of the arbitral institutions, the administrator of the arbitral institution is given the power. So as long as you refer it to the arbitral institution, and the administrator will take a decision whether A should be appointed or B should be appointed. That system is also there in arbitral institutions. But I would like to have in our system a choice of the people who are into litigants, because what I would like to look at is one, mediation, because a mediation ultimately, when it ends with a contract between the parties. So the question of further disputes arising is less. Either mediation is abandoned in between as unsuccessful, or if it is successful, both parties sit together and sign a conciliation agreement and ends the matter. So there is no further disputes which are likely to come. In the case of arbitration, if the arbitration doesn't happen properly, it will go to a court. So there may be a situation tomorrow that court may pass remarks about FDPPA arbitration not working properly or something like that. So to avoid that, initially we are taking up mediation. Second, we are taking up non-binding arbitrations. Why I say non-binding arbitration is, there is a view which some of the lawyers have expressed, and I may like others to perhaps clarify, including persons like Vishwanath, who is here, that where there is a statutory basis for a dispute resolution, some people feel that arbitration would be struck down by the court. My view is binding arbitration can be struck down by a court, but non-binding arbitration cannot be struck down as per se illegal or something like that. For example, we were discussing with one of the other persons about the employment contracts. I understand that sometimes when a company wanted to have an arbitration clause into the employment agreement, the labor commissioner raised an objection. And my view is that maybe the arbitration clause was a mandatory clause. That is, the person will have to subject to arbitration and he will have no other recourse. If you write it like that, then the labor commissioner is likely to have objection. But if you say that this arbitration will be the first step in reconciliation, slightly better than mediation, because in the mediation, we don't give too much value to the law. Whereas, and it is always a mediation which the two parties themselves come to an agreement. Whereas one step higher is conciliation, where the mediator tries to actually suggest some solutions. And ultimately, it is still another form of mediation. So mediation and conciliation end up with the parties agreeing amongst themselves. Whereas in an arbitration, a third party sits and gives a judgment. And when he gives a judgment, it is likely that one party is likely to be unhappy. So if you say this is going to be binding, you will not have any recourse to any court, then there will be this question that a special court is there, labor commissioner is there, you cannot take away his powers by your arbitration. I think that was the reason why perhaps this particular company had a problem. And even then, I think this was a problem prior to this 2015 law or something like that. So today I feel non-binding arbitration should be considered as acceptable. And we in Data Protection Act have to go for non-binding only because the Act itself provides for adjudication. So when the Act itself provides for adjudication, I cannot say we will make the arbitration so binding that a person cannot go to the arbitrator, the adjudicator. Therefore, we are trying to use the system for mediation and then non-binding arbitration. Okay. So on this point, PB Vishwanath, do you have any views? I saw you there as one of the participants. You are one of the more informed lawyers. So do you have a view, Vishwanath?
Hi, good evening, everybody.
Yeah.
Thanks, Navi and others. It was a very useful and informative session. And thanks for giving me an opportunity to speak. And I would like to add a couple of points here. The arbitration mainly, in my opinion, is based on the principles of natural justice. So, it's important to have the knowledge of the subject, both technical and legal. At the same time, the principles of natural justice should be upheld at any cost. That is number one. Number two, on this non-binding clause, like where a party cannot approach the courts for dispute resolution, in my opinion, any contract which has such a clause itself is invalid. So nobody can stop an individual from approaching courts for redressal of his grievances. So these are the 2 points I would like to make, Navi.
And
Okay,
this
now
position,
one of the concerns you said, this principle of natural justice. So what I intend, as far as our DDMAC system is concerned, I am going to suggest to people, as I told you, arbitral tribunal is different from FDPPI. So that is one concept. But I am going to suggest that the one person in the tribunal of 3 people should be a law person, so that he is aware, and particularly if he is a person having 10 years of experience, that is the qualification required under the Arbitration Act itself. A person who has got 10 years experience as a lawyer, 10 years experience as a chartered accountant or some other specialized area, they are all considered eligible for being arbitrator, even in a arbitral institution accredited to a court, etc. So now here also, I don't know whether we can stick to 10 years or slightly reduce it, but a legal person with a minimum of 5 years of experience should be a member of such arbitral tribunal. The other 2 can be technical experts or experts in data protection law, so that the legal person will take care of the principle of natural justice, and the other 2 people will ensure that required technical knowledge is there. This is a suggestion which I want to make. Maybe this is one of the suggestions which perhaps Amit should look at including in the rules also. In the case of cyber appellate tribunal and other things, we always say it can be a multi-member body. The chairman should be a judicial person. The other person may be a technical person. So similar concept we can use here. In a 3-member this thing, one should be the lawyer. In fact, if you look at our Data Protection Authority Constitution, which will have 7 members, 1 plus 6 people, the law says that there has to be a legal person. It doesn't say the legal person has to be the chairperson. So the person who actually heads the panel may be the most senior person. In the DPA, obviously, he can be a technical person. Legal person will be one of the other 6 people. Similarly, I would like to adopt a clause in our suggested rules that we will try to go for 3-member this thing, not 1 member, because we will be perhaps be able to pull the talents. And out of the 3 members, we will say 1 person has to be a person with a legal background. If we have got 10 years experience, it is fine. Otherwise, minimum 5 years of experience. The other 2 can be the technical persons. But I will be leaving it to the tribunal to decide who will be the chairperson and who will be the co-member of something like that. I think this should address the concern perhaps Vishwanath has in his mind, that technical people alone sitting there and trying to write an arbitral award will be a problem, because writing of an arbitration award itself is a skill, because though we are saying that this will be a non-binding thing, even in any arbitration, had it been a binding arbitration, then it would have gone directly to the High Court for appeal. Say the Arbitration Act provides for appeal under certain conditions, so it will go there to High Court or the Supreme Court. Now here we are calling it as non-binding, so that my idea is, what is the value of this non-binding award compared to a mediation? This is a question which people ask me. I say that if there is a good arbitration tribunal, and if it writes an erudite judgment or award, that award will be a great basis for the court to take a decision, because the court itself may feel that their expertise is less, but when they look at a arbitral award issued by 3 experts who have got specific knowledge of the data protection laws of multiple countries, perhaps we are placing before the appeal court that sort of a fine, you can say, expression of why the arbitral tribunal has come to a particular decision, the arguments on for and against the particular thing, case laws if necessary, everything can be put in. So if the arbitral tribunal is good in writing a report, that report, the High Court should say, I have got a great report here, I don't have to add anything more, I will agree with this and close the case. So the appeal can come more faster. Okay, so Amit wants to say something on this.
Yeah, I want to make a point here that there are 2-3 things which you just mentioned. First is the ousting of jurisdiction of civil courts by the arbitration clause in the contract. So it is a very well settled position that merely by the existence of an arbitration clause under a contract, binding arbitration clause, it doesn't oust the jurisdiction of the civil courts. Okay, unless the arbitration actually commences and a party files the statement of defense, not only the statement of claim. Until the statement of defense is filed, it is a settled position, and even the Supreme Court has held it in the case of Mahesh Kumar versus Rajasthan State Road Transport Corporation, that mere existence of an arbitration clause doesn't oust the jurisdiction of civil courts. That is one. Second is, you said that there will be an arbitration tribunals which FDPPI will prefer to have rather than being an arbitral institution. What I feel that arbitral tribunal gets operative from the contract of the parties, and the parties appoint arbitrators. That if there is a 3 arbitrators clause in the contract, each party appoints 1 arbitrator, and both the arbitrators appoint 3rd arbitrator. Or if there is a sole arbitrator clause, then the parties appoint a sole arbitrator. That arbitral tribunal gets functional after their appointment. What you're contemplating as is that we will have arbitral tribunal prior to the parties getting into dispute, and they will have a clause in their contract that we will refer it to the FDPPI arbitral tribunal. I think that's a tricky situation, and we'll have to look at it, that whether this kind of prior constitution of arbitral tribunal is possible before the parties invoke the arbitration clause and constitute the arbitral tribunal. So, I mean, others can throw light on this.
What I'm suggesting is that we will be having, let us say, 10 or 15 registered arbitrators on our website. Okay. Basically, why I want them is I have to train them on how to use our ODR system, because our ODR system will mean a claimant will first raise a request to the administrator of the particular platform, saying that I want to use your platform. Then I will ask the next question, do you have an arbitration clause? Who is the other party? So he will perhaps submit his contract and say, this is the contract, based on which so-and-so is the respondent. Then I will have to write a mail to him asking for his permission, whether he is agreeable to use this. If the arbitration clause is not clear, if the arbitration clause is already told that you can use DDMAC, that is different. But right now, we may find many situations where arbitration clause may be thought of post-dispute also. Okay, so one person makes a request that I want to use your services, so-and-so is the respondent. I will send another email to them, and let us say he also agrees. Now, both the parties have agreed to use this DDMAC as a platform. Then the question of selection of arbitrators come. Then perhaps as an administrator, I will suggest, if you have somebody in your mind, please suggest we will let our platform be used by them. Or you have got this 10, 15 people with us, please select. Now, out of these 10, 15 people, 2 or 3 people may say we will always act as a group kind of a thing. That is their choice. Okay. Or all the 15 people may be separately there, and these people can pick, as I told you, one person picks each, and they find the 3rd person. So the arbitral tribunal gets formed at the 2nd level after the consent given by both the parties. Then we have to write to these arbitrators saying that here is a 2 litigants who think that you are the persons who are to act as an arbitral tribunal, and then they will have to agree. Okay, now there is a question of fees and other things here, expertise and fees, both are there, and based on which, let us say, the disputants suggest that 1, 2, 3, these are the persons we want, and that 1, 2, 3 will be the administrator of the panel will be of the platform will write to them, and will with some details of what is the dispute, etc., because they need some background information. And also there is a conflict situation to look into. You know that arbitrators cannot have any kind of a conflict with the parties. So if the arbitrator has at any time been associated with either one of the disputing parties or their companies, etc., he may be in a conflict situation. So identity of the litigants will have to be given to this, you can say, potential arbitrators. And let us say in an ideal situation, the arbitrators also agree, okay, if there is no conflict, because conflict, they have to give a declaration. You know, in the Arbitration Act, the arbitrator has to give a declaration that I don't have a conflict. And that becomes an important declaration from them. Tomorrow, if they give a wrong declaration, the arbitration process can be dismissed because of that reason only. So they will look at who are the persons involved in the litigation and give their consent. Once they give a consent, we have these 2 litigants and let us say 3 arbitrators, 5 parties fixed. Then I will ask this chairman of this arbitration panel, arbitral panel. Now you tell me, you are the owner of this arbitration room. I will just give you an arbitral room. I am just your servant, a technology person. You tell me when do you want to have the hearing or something like that. Then I will only provide my back-end service to him. At the request of this arbitral chairman, I will send a notice to both the parties that we will hold a hearing on such and such a date, or both of you have to submit your initial representations. Then I will go through that, and then I will fix a time for the hearing to hear them physically. Then I will say, give me a list of witnesses, give me a list of documents, exchange it with both the parties. So all this will go one by one at the instance of this arbitral tribunal. That is where I say that initially we will act as a platform and we will pass on the control to the chairman of the arbitral tribunal so that it becomes the property of those 3 people. And we at FDPPI, our role will revert to only providing or facilitation of the room or something like that. That is how I am trying to conceive, so that the legal responsibility of FDPPI becomes that much less. That is, we initially facilitate the choice of the arbitrators, but once the arbitrators are selected, all the 5 people form a team. I don't have to say anything more. I have to actually sit there as a registrar, take notes of when was the hearing done, etc., etc. That I will do, but I will not interfere in any of the decisions of the arbitrators. It is entirely done by them. This is the concept which I am trying to put in. Yes, Amit.
No, see, I defer to this point that, see, all the arbitration institutions which are functioning today, they do not undertake the responsibility of whatever proceedings takes place in the arbitral tribunal. There is always a clause, and even there is a clause in the rules which I have drafted, that the responsibility of the arbitration center for DDMAC is only for as a facilitator. So there is no responsibility assigned about the proceedings, what goes on in the proceedings, and there is always a limitation of liability clause in all the rules drafted by any arbitration center. So similarly, we will not have any responsibility. Secondly, as to the recognition of the arbitration center by the Supreme Court or the High Court, the point which you made under the 2019 amendments. 2019 amendments under Section 43 also contemplate the establishment of the Indian Arbitration Council. Okay, so the Indian Arbitration Council will recommend the grading of the arbitration centers, and based on those gradings, the High Courts and Supreme Court will recognize and they will grade the arbitration centers. Those grading will be done on the basis of their infrastructure, their performance, their knowledge, their technical expertise, and their domain knowledge, and all those criteria are given in the 2019 amendments. Now, but at present, this Indian Arbitration Council, the composition of the Indian Arbitration Council as contemplated under the 2019 amendments is not comfortable with any of the players in the arbitration arena, that out of 7 members, the 6 members are the representatives of the government. So as government is the always in most of the cases, government is also party to arbitrations. This council is objected and the council is not yet formed. So as on today, the accreditation of the arbitration centers by the high courts and supreme courts is not in place because the link that the council is not yet formed. Okay. So as on today, for any center to become an arbitration center and to have their own set of laws does not require the recognition by the high courts and the supreme courts. Only thing is they have to have a separate legal recognition as a legal entity, or at least to for accounting purpose they should have clear legal status. That is the requirement. And they can form rules, they can create arbitral panels of arbitrators. So my opinion is, even if not full-fledgedly making activating the arbitration and mediation at one go, we can go by step by the mediation at the beginning, and thereafter gradually going to arbitration. That should be the course of action. And when the parties will have a look at your arbitration center, I mean FDPPI's arbitration center, and if it is not a fully equipped arbitration center and it is just a platform, I think the parties submitting themselves to the DDMAC will be a little difficult, because it will not be a full-fledged arbitration center. It will be just a platform, and the panel of arbitrators will be something detached sort of from DDMAC, and DDMAC is not going to take any responsibility. So I think that is how we should think, that we should go ahead as an arbitration center with a full set of arbitration rules.
Yeah, I understand what you are suggesting. Now, presently, what I have tried to do is to adopt a cloud kind of model. Why I say cloud model is, we have a base infrastructure, okay, like cloud infrastructure, which is being provided by ODR Global. All the technology cost, everything will be taken by ODR Global. Now, on that, FDPPI will be a cloud platform, like cloud platform. They will be the arbitration platform on which the players will do the transaction. This is the concept I have in my mind. We will discuss it separately because like many other things, sometimes what I suggest is something which may not have a parallel. So the question of whether it is acceptable, not acceptable, need to be discussed. But this is how I'm looking at the layered responsibility. Because FDPPI being a not-for-profit organization and we are to take care of our reputation, we have to reduce the possibility of some kind of, say, some arbitrary panel not doing their work properly, kind of a thing should not affect our reputation. So I'm trying to think about it, but this requires a more detailed discussion. We have already completed our allotted time. So I will just try to summarize with some of the questions which I have received, which is Mr. Kamal Acharya, FDPPI, will it have a scheme for various organizations to voluntarily part with the arbitration, voluntary take part in this? Yes, that is, we will be having one list of arbitrators, one list of mediators, and we will be saying that a person who is not otherwise connected with our organization also can become a listed arbitrator. So if somebody is an expert arbitrator already, as I told you, I will not sit in judgment of his capability. I will provide him a listing here. If somebody wants to take him, let them take him. And since arbitrations or mediations have to originate from the contract, either an organization can take a policy that I will try to adopt this arbitration or the mediation as one of the mediums of grievance redressal for all my contracts. In that case, you are talking of listing of potential corporate entities who wants to adopt this becomes relevant. For example, if you are an e-commerce company, you are having thousands of transactions, likelihood of hundreds of disputes. If you want to adopt the FDPPA platform for data-related disputes, we will welcome that. And if you have got a code of practice and you want to say that this is the code of practice which we would like to follow, we can give a possibly exposure on our this thing, saying that these are our clients who are likely to use the particular service, and this kind of commitments they have got. So that is possible. So I must say here that this is a very significant step we are planning for FDPPI. It is not a small step, okay? And we are actually getting into realms where we are going to clash with the legal interpretation. Tomorrow people may question, as I told you, whether you can have an arbitration. If you can have an arbitration, I personally feel non-binding arbitration and mediation, there should be no reason for any court or anything to have objection, because I am trying to get some kind of a resolution at one level. After that, if they are prepared, capable of going to the normal judiciary, I don't see why judiciary should be unhappy about our system. As long as we are honest and in good faith, we are trying to do things. So I don't see much of a problem, but still, this is a very it's unknown area. Even in India, if you look at it, some of the cases which we are talking of in Supreme Court, they are all cases which are based on the old law, pre-2015 law. So sometimes when we look at the judgments today, we have to keep in mind that maybe if a case starts under the 2019 or 2020 law, the same court may come to a different judgment. So we are looking at taking that stance that we propose something which we think is good in principle. We hope that the courts will also appreciate this when somebody goes and challenges it there and say FDPP is doing something which they should not do. We will see how it turns out. But our idea is that the litigation related, you can say, burden should be reduced for the companies and for data principals. You can't expect a data principal to go and file a case in Delhi against a Airtel or something like that if there is a dispute. It will never happen. So the person may send a few emails and afterwards he gets frustrated and he leaves it. So we want to ensure that Airtel adopts us as a sort of a dispute resolution proposal. Then these individuals, if there is, in case Airtel is really interested in resolving this, they can tell these people that you can use this. These Lok Adalats, you know, in telecom companies, they are all not very satisfactory as far as the individuals are concerned. So there is a scope. I just took Airtel as an example, as a telecom company. There are other companies who are providing various kinds of services. And if those companies adopt us as part of their dispute resolution system, then to some extent, we will be having some break-even business for this center. That is one separate thing. And if it should actually be considered as a reputation building for that company also, because they are customer friendly. They are giving an online arbitration or dispute resolution mechanism, which starts with not necessarily arbitration. Arbitration is the final stage. First thing is an ombudsman. So I feel that we will also give an ombudsman service. Okay. And if a dispute is referred to the ombudsman and ombudsman gives some view, if the parties accept it, there ends the matter. It doesn't become a grievance at all. Then next level, we will have a mediation. If mediation also fails, they could go for arbitration. And if arbitration also fails, they go to the adjudicator. Anyway, in PDPA, it will become mandatory for them to go to the adjudicator. So this is how I want to see that FDPPI contributes to the reduction of the litigation. May not be elimination of the litigation, okay? But when, and also you remember that whatever we are proposing in the ODR global concept is adjudication. We are planning to have a recording of the session which will be certified under Section 65B of Indian Evidence Act. This is not applicable to mediation because mediation is a confidential activity, no recording, not to be used anywhere else. In fact, I may use proctoring system to ensure that the users don't misuse the system, users don't try to record. If they try to record, my proctoring system should be able to find it out. So some measures of control will be there for mediation. And nowadays, nobody is using proctoring. If we start using it, we will be first people to use it. We will, but I think we will do that. We will have a proctoring system whereby the user will not install any recording software in his computer, and otherwise we will try to restrict that. In the case of arbitration, we want to record it and have a judicially presentable evidence. The reason why I want this is tomorrow, if it goes into a genuine appeal, the court will have the entire proceedings at its table, so that if somebody is accusing the arbitrator of not being properly handling the arbitration hearing, the judge can see himself whether that accusation is true or not. And also the arbitrators themselves will be more accountable, because they know that the session is getting recorded, so therefore they cannot be arbitrary and favor one party over the other, because prejudice of the arbitrator is also something we have to take into account. So this is some of the thoughts which I am having at this point of time. It will take some time for this to be reduced into actual words and rules and other things and rolled out. But as I told you, we'll start with mediation first, because that is the least controversial. Then we will expand. So I wanted all the members to have an idea about what we are trying to do. That's why I thought this session was important. Okay. So if you have a last word, anything to be said, Amit, after that, Samyogita can close it. Okay.
No, thank you very much for this opportunity. And certainly you have been a path-breaking thinker in case of online resources and online dispute resolution systems. So I think your vision will certainly come true, and we all can make it happen. Thank you very much.
Thank you, Mr. Amit and Mr. Navi, for that insightful discussion on mediation and arbitration. We definitely have new opportunities that the law enthusiasts can take up. The discussion was very detailed, and we are now aware as to what will be the upcoming rules for the ODR process. Thank you, Mr. Amit, for taking out time, and Navi, as every Wednesday you're dedicating your time. Have just floated a small request to everyone to kindly go to menti.com and use the code 3401907, and even the link is shared. And kindly share your responses as to how do you find the FDPPI Janavardhani webinar series. And we would present to you as to what is the, just give me a minute. Navi sir, if I can share. Just take out everyone your time, and we can just see how the session is useful to everyone. Is my screen visible, Navi sir? If I can just get a heads up on that. Yeah. So kindly just click on the link and let us know how insightful the sessions are, or probably what are your views on the session, so we can get a window to improve on it. If you start typing in, it would come up here. Yes.
Okay. Thank you.
Okay, everyone can go through. I will share it on the group later. Thank you.